All right, so what do we think about what's going to happen recently now with the judges? There's new rulings on the bond stuff from the federal courts. Anybody reading up on this?
So I saw the ruling that came down from Judge Rosenthal, but I have not seen how it's being implemented, or haven't seen anything that's going on in the courts. Either of y'all?
I think it's going to amend. Well, it still says that individuals who cannot pay bonds for misdemeanors still need to be released.
But
However,
there's certain misdemeanors that they can set a monetary bond for.
So, for example, assault family members.
Right.
Assault family members are individuals who are accused of assaulting either girlfriend, boyfriend, past girlfriend, past boyfriend, roommate, because the definition of family member in the family code is a little bit broader than what we would expect as a plain reading of the language. And so what the judges are able to do now is set an actual monetary bond for them. And what that will do is not give them a personal recognizance bond. However, I believe it will still allow those individuals who are accused of those types of crimes to be released after a certain amount of time, which I believe might be 24 hours or 3 days, one or the other.
72 hours is the typical.
72 hours with an via an unsecured bond, which is a SOB bond, which is a sheriff's bond. In other words, you're not going to be released on an unsecured bond. However, you'll be released on an you won't be released on a personal bond, but you'll be released on an unsecured bond, which means you'll be liable for the money that they present for you if you don't show up to court.
So are they abiding by this?
Yes, yes, and the judges have been abiding by something similar for some time. So the order from the federal from the federal circuit says, hey, look, you can't hold people who can't afford bonds in jail. But, and they've also ordered the sheriff, though, simultaneously, that says, hey, for these individuals who don't necessarily qualify for a personal bond, so you're accused of a assault family member and some other crimes that fit within that category, basically threats to other people, we're going to give you a monetary bond. The judge will say your bonds are worth $3,000, but if you can't pay that within a certain allotted amount of time, it used to be 24 hours, and at least at this point, the amendment will say 72 hours, that you're going to be released on what's called an unsecured bond. So
who's going to monitor that?
Well,
why are they putting a time period on it too?
I believe it's 72 hours.
The
if
Fair
I'm not
Defense
mistaken.
Act has teeth in well before this lawsuit. Mm-hmm. The Fair Defense Act has teeth that is kind of the grounding network of understanding current bonds in Texas. But it still depends on counties. Harris County has a direct intake. A person could be arrested before a magistrate in 18 hours. Somebody in Odessa might be arrested and not see a judge for 6 days. And then, heck, that magistrate might set a bond that's incredibly high.
Oh, like the one in Waco?
Well, yes. So Harris County is unique, really unique in the state of Texas, where that they have magistrates that are reviewing a bail schedule presumptively reasonable, which it's not, and under scrutiny of a federal lawsuit. But at least we have these people that are brought before a tribunal to have probable cause read to them and a bail ostensibly set, even though today I got appointed a case where bail was set on one case but not on another.
And you're starting to see a difference between what the magistrate's bond will be, or the monetary bond that will be from the magistrates, to what the actual county court at law judge's bond would be. And you're starting to see conflict between the two.
JV, we're not starting to see this. I never mean to disrespect you. We've been fighting this issue for decades.
Well, I think what he's saying is that there's a discrepancy between the bonds that the magistrates are now setting versus the misdemeanor bail, the bond schedule, but prior to, they were following the requests of the misdemeanor judges more so than perhaps they are now.